Well, it's that time already. Time to talk law. Our resident lawyer, Despina Priala, of boutique law firm Priala Legal in Runaway Bay, with us every Thursday morning at this time to offer her legal expertise. She provides some general advice on the latest hot topics. She has experience that spans more than 25 years in areas including property and commercial law. She also prepares wills as part of estate planning and litigation. With us this Thursday morning. Hello, Despina.
Hello, Wayne. Hello, Brooke.
Good morning, Despina. So this morning, another hot topic for you. The Real Estate Institute of Queensland, which we fondly call them the REIQ for short, have just changed their commercial sales contract. So if anyone's looking to buy, this is some really important information, Desi.
It is. So if you remember, we talked about the changes to the REIQ residential contracts that came into force on the 20th of January this year in Queensland. We're talking about, not any other state. And then we had a couple of segments back in Jan and February this year on the show where I gave listeners basically a rundown and a summary of what those changes were. So now, 6-7 months later, we've had the similar changes to the commercial contracts, the REIQ commercial contracts in Queensland, which I'm very happy to see, because when the changes came out to the residential contracts, I was thinking, well, okay, how long will it be before we can see the same changes and their beneficial changes to the commercial contracts in Queensland? So now they're here and they've taken effect from the 21st of July. So we have new contracts for commercial property, and with the similar changes to residential. So we want to talk through some of those changes for the listeners out there.
And you mentioned that date there, 21st of July. So all of these changes are now in operation.
They're now in operation. So say if you are already under a commercial contract prior to the 21st of July, you don't simply cancel that contract and enter into a new one. You're still under that old contract. Okay. So those terms still apply under the old version. But if you're going to buy commercial property after the 21st of July, we're now in August, of course, you'll be using the new version of the commercial land contract or the commercial unit contract, depending on whether you're buying a unit or land and house or buildings and land, I should say, for commercial purposes. So yes, let's go through some of the significant changes. And the reason why, of course, these changes come about, if I can say first up, is to obviously streamline the 4 sets of contracts we have in Queensland, being 2 lots for residential, house, land and units, and 2 lots for commercial, being land, buildings and units. So now we have the 4 contracts really streamlined, and it's just going to improve consistency across the board. So I'm pleased to see it, although it took a few months, but we're here now. So let's go through these changes. So one of the significant changes we saw with the residential contracts, really important change, was this unilateral extension right. You might remember that we talked about this. So now under these contracts, there's this unilateral extension right given to either a buyer or a seller, where you have up to 5 business days to extend your settlement date without giving any reason. And it's not a request. So if you get stuck on that settlement date, you know you can't settle, you can actually exercise this right to say, I'm exercising my unilateral right under this clause 6.2, and we're going to extend the date, whether it's 1 day, 2 day, you only have up to 5 business days. That's the maximum. So you actually have this right now in commercial contracts. So that's a really big plus and a good consistency.
Yeah. And is that mainly because of the delays with certain banks and maybe things not getting in on time that are just out of your control? Was that similar to why it changed with the residential REIQ?
It is mostly because you're relying on banks. Yeah. And in this market we've seen for quite some time, a period of, say, 14 days is not enough time for these banks to be ready. So yes, that's essentially the reason why. You also might have a tenant that's in a property that's supposed to have vacated, and you're supposed to give vacant possession, but they haven't vacated yet. So it just gives you that buffer without any penalties, without any costs or anything like that. So it's a really important right we now see in the commercial contract. So that's the change that's come into play, which is great. Another change that we saw in the residential that we now have in the commercial is that we have new warranties for sellers. So part of the new regime for the residential contracts in Queensland, this year was to have a bigger disclosure requirement on sellers. And now we see that again in commercial contracts. So that's really important, particularly for commercial. So we have new warranties about the sellers having to disclose things like show cause notices, enforcement notices, disclosures of communication from local councils that may lead to those notices, which we didn't have before. So now we've got that in the commercial contract. So that's really important. Another change we have is things that the seller has to hand over at settlement to a buyer. And we've now got a requirement where the seller has to hand over a certificate of occupancy for a commercial building. So that's really important. So that's something to keep in mind for sellers when they're selling commercial property, that they simply have that requirement now. So they'll have to investigate if they're selling a commercial property, whether there was one ever in existence or whether there was one, but they've lost it and misplaced it, and they'll have to find it. Okay, to hand it over to the seller. All right, so to the buyer, sorry. So that's really, really important. So that's a requirement. And the other important change that I suppose I want to point out, because it's not really something that came about in the residential, but we've always had it as part of the commercial, is land tax. Okay, so we've talked about land tax in the past. So one big significant difference between residential and commercial under the REIQ contracts is that under commercial contracts, you do have land tax and you can adjust for land tax. So what that means is that under residential, you adjust obviously for rates and water. So the seller pays their portion, the buyer pays their portion, right? So seller pays up to settlement, the buyer pays after settlement. Land tax is never part of residential under REIQ, but land tax is part of commercial. Okay.
Yes.
So yeah, so really important for people to understand and be aware of. And what we want to talk about with the land tax is something that people might not be aware of, that the current commercial contract provides for this adjustment for land tax, but it does so on the basis that the seller is a natural person resident in Queensland. So we don't want to get overly too technical here, but we want to try and explain it simply for listeners out there.
My face, I hear natural person, and I just
okay.
Talk proper. What? Yeah. What does that mean?
Yeah.
Okay, so this is all about a seller wanting to make sure that they can actually recoup some land tax at settlement, right?
Okay.
So if a seller is selling commercial property, if you remember last week, I think it was, or the week before, we talked about land tax thresholds. So in Queensland, if you own a property as an individual, land tax thresholds are 600,000 plus. Right. Okay. So if the unimproved land value of property is under the 600,000 and you own it as an individual, then you won't get land tax. But if you own it as company or trust, the land tax threshold's lower. It's 350,000. Okay. But the contract, the current standard terms under your commercial contract, the way that it's worded means that regardless of how you own it, you'll only adjust on the basis that as if you own it as an individual. So say if you own a property as a company and you don't change the standard terms at all, you just leave it as it is. So that means that if the unimproved land value is over 350,000, but it's under 600,000, so it's in that bracket, you actually can't adjust for land tax because the contract says you can only adjust it on the basis that you're an individual, right? So it's but only if it's over that 600,000 threshold. So what you would do as a seller, if you're really careful, then you get that pre-contract advice we always talk about is if you are a company, you want to change that. So you can delete it and say, well, we're not going to adjust on that basis. We'll do it as if we're a company. So then you would recoup some money at settlement. So this is about sellers making sure they can get the most that they can from their sale of commercial property. That's all. It's something that a lot of people aren't aware of. So you just want to be really super careful with commercial, because when you have commercial, you think of, yes, land tax applies. So we want to make sure we cover that off really well.
Yep. So it sounds like one of those things that you need to talk to a lawyer about before you get to that date.
Commercial property is something that's quite different to residential anyway. So you'd be really quite silly to sign a commercial contract, whether you're a seller or buyer, without getting pre-contract advice. So definitely always get that. But just for today, we want to tell listeners that these changes are now in place and they should be extra careful when signing up under a commercial contract.
Definitely. Thank you so much, Despina. And coming up next, pet owners on the Gold Coast. Laws may be changing very soon. Despina has all the details coming up on Talking Law. You're listening to Radio 97.